Good afternoon and welcome to Porzio's Estate Planning Checkup. As we're filming this today, it's June 2020. We are currently in a work from home, stay at home situation. So you see Crystal and I joining you live from our own environments. But since people are staying at home right now, we've had a lot of people who've called us saying, hey, it's a good time to take a look at our estate plan. So we thought it'd be value to bring to you some of the questions that you should be asking about your own estate plan to make sure that it's going to continue to work for you going forward. So I'm Deirdre Wheatley-Liss. I'm a principal at Porzio. I'm in the wealth preservation team. I focus in helping families with estate planning, elder law, asset protection, and tax questions. Crystal, you want to introduce yourself?
Crystal West Edwards, thank you everyone for joining us. I'm also in the wealth preservation, on the wealth preservation team. My practice area is estate planning, estate administration, elder, and special needs. So we plan for people at their most critical time in their life.
So if you can go to the next slide, we actually want to start with an announcement. Crystal and I have been working diligently on the question of how do we bring more value to our community based on what it is that we do as attorneys. So recently launched as of last week is porzioplanning.com. This is a resource for people who have any questions about estate planning, asset protection, elder law, guardianship, special needs, estate administrations, lots of things that you might be calling us for, but to give you and your family and your friends a resource to be able to go to. There's lots of articles that we've put together on there. There's free tools that you can download, and we certainly hope that you'll take a look at the site, and any feedback is greatly appreciated. Turning to our first slide, though, when we're looking at estate planning, what question do we start with? And the question is, who is your family? And for some of you, that question is very obvious. So it's my spouse and my kids. Okay. Not the same for everybody. When we think of if you're doing an estate plan checkup, the first question is, who are you planning for? So it may be a spouse, it may be your children, it may be siblings, it may be your fur babies. Who is it that you want to be able to benefit? And from a checklist perspective, the first thing that I recommend that you do is that you actually do a list of everybody that you're concerned about. Maybe you're taking care of your parents, so you want to make sure that should something happen to you, that they're going to be provided for. Maybe there's some kind of family property that you want to make sure that everybody's able to continue to enjoy it and continue to have Thanksgiving dinner together with each other. So the first checkup point is looking at who's your family and making a list of that. Next slide.
The next thing that's important is, what do you have? What do you have that you want to provide for not only yourself, but for your future generations as you're thinking about those loved ones that you would ultimately be inheriting your prized possessions. Personal property is extraordinarily important. It's the stuff that we don't necessarily think about day to day, but it certainly is things that are important to us or to our loved ones, especially if it's things that have sentimental value. Maybe you never really cared about that painting that was on the wall, but one of your daughters loves it so much that they could not envision looking at it every other day when you're gone. That's something that we would want to identify and make sure that the things that are special to those who we love are able to enjoy them when we're gone. Are there cars? Do you own property? Bank accounts, the titling of them, which we will end up talking about a little later on today. Investment accounts, retirement accounts, insurance policies even. Once we've identified what the assets are, it's important then to think about and to identify whether or not our wills would control those assets, as opposed to beneficiary designations to ultimately ensure that your testamentary intent is protected. Digital assets are one that we don't often think about, but we do see in the news from time to time these days. If something happens to me, who can access my Facebook account? Who can access my personal records that are on tdbank.com if that's who I'm banking with? We'll go through all of these in a little bit throughout the presentation, but we must identify what we've got.
So, and just before we go to the next slide, if you are doing your own estate plan review on porzioplanning.com, we actually have a download tool that's a financial worksheet, because from an estate planning perspective, we're looking at what the gross value is, the top line value of items, but we also need to know who owns it. Is it joint? Is it owned by one spouse? Is it owned by the other spouse? Can you go to the next slide, please? Thanks. So we now know who your family is, who you're planning for. We know what your assets are. So the next question is your estate plan complete? And in order for any estate plan to be complete, there's 3 documents that you have to have. The first document is a last will and testament. This is the document that says, should I get hit by a meteorite, this is who gets the items that are in my own name, not in joint name, and items that don't have any beneficiary designation to them. Within the will is where you'll maybe set up trusts for children or for your spouse. You'll do tax planning. Maybe you'll say a specific bequest. That's the will document. But that's only one of the 3 documents that we need to look at. The next one is a power of attorney. A power of attorney allows somebody to make financial decisions for you. If you were hit by said meteorite, you don't pass away, but you're incapacitated. You need to give somebody else the authority to make those decisions for you. That's done through a general durable power of attorney. And when you do that, that allows somebody that you name to make financial decisions for you in whatever your best interest is. Unfortunately, a lot of people don't have a power of attorney, and should something happen to them, we're forced to go to court to get something called a guardianship so that somebody has the ability to manage their affairs. The last one that you need to look at is a healthcare power of attorney. A healthcare power of attorney is a document that says who can make medical decisions for me in the event that something happens to me. Given that we are doing this during the COVID crisis, just an extra point from a checklist, read through the language. Many powers of attorney for healthcare have language regarding the use of ventilators and things along those lines. That may not be what you would want in the current situation, so we encourage you to look at that. In addition to those 3 foundational documents, some plans might have something else, maybe a revocable trust. A revocable trust is a will substitute, and what it says is that instead of all my wishes being in my will, my wishes are going to be in this revocable trust. It's a tool that we use, particularly for people who maybe live in a jurisdiction other than New Jersey, where probate's very expensive, or alternatively, people who maybe have real estate in different jurisdictions. That may be an add-on to the basic plan. You still need a will, though, even if you have a revocable trust. And then the final document that you might have is an irrevocable trust. This is usually a trust that's created for a specific purpose. Maybe we're doing gift tax planning, asset protection planning for an older adult to be able to set aside some of their assets so they're not subject to a forced spend down. There's usually a particular reason that we would put an irrevocable trust together. Next page.
There's one more thing on that I also want to mention while we're doing that. And if we can go back a slide, that would be great. So of the documents that are critically important, one of the questions that I've been getting often in this COVID environment has been about funeral instructions and whether or not people's wishes with respect to how they would want to be honored and remembered after they have passed away are implemented. It's an interesting discussion because oftentimes, and Deirdre can tell you, we have clients that do not want to think about when they die. That's why there are dozens of hundreds of people out there who don't have estate plans. But for those that do have estate plans, there's an even smaller percentage of those that want to plan for what happens when they pass away, i.e., do they want to be buried or do they want to be cremated? And so one of the things that we have seen is an area of discomfort for families is if there's a mixed message with respect to how you want to be honored after you've passed away. If you have any type of feeling about burial versus cremation versus being dumped off of some boat out in some remote land because you don't want your family to spend any money on your funeral, it really is important to say. And in New Jersey, those funeral instructions and the appointment of a family member or a friend to make those funeral decisions for you must be stated in a will. Unfortunately, that's the only document for which our New Jersey law provides, although there are funeral homes that would allow you to make that designation. So it's just something to think about. It's not the most critical, but if you have feelings about it one way or the other, it's important to put those desires in writing. Once you've reduced those things to writing, you always have to look at it. So a question that we will often get is, when do I have to look at this again? And if I do this will, does it mean that I'm going to have to redo it 10 years from now? Life happens, things change. People get married, divorced, have children, adopt children, get rid of children. They go off to college and leave the nest. They have babies of their own or not. Things change. And so as life changes, it is important to look at your estate planning documents and whether or not ultimately your desires have changed. At one point, someone may say that they want their 401k that they invested in their whole life to pass to their only niece. Lo and behold, by the time they pass away, there are 5 nieces. Well, was that really what they wanted, to provide for one or to provide for the 5? So as life happens, it's worthwhile to pick up your documents and see whether or not there are additions or revisions that may be necessary to them. Especially important here is when you have appointed someone to make your medical or financial decisions for you by way of a power of attorney or a medical directive. As life happens for you, it also happens for your trusted advisors. And so there could be other circumstances that would impact your loved one's abilities to make decisions on your behalf if that's who you've chosen. So in addition to looking at your documents, it would also be helpful to touch base with the people who you trust to see if they would be able to step into your shoes if needed to provide for ultimately either your care planning or the decision making at a future time. Next slide.
Right. So one of the things I've talked about is trust. And I think that there's a misconception out there that only really, really rich people use trust. That's just not true. Trusts are a foundational part of all of the planning that Crystal and I do. Everybody who thinks about doing estate planning deserves to have the knowledge about how a trust could be able to help them in terms of what it is that they're doing. And by the way, if you don't have an estate plan, you got some company, because statistically 70% of Americans do not have estate plans. I think Crystal and I find that somewhat ironic, since I'm pretty sure 100% of us are going to need them at some point in time, because a nice way to put that. So what's a trust? Think of a trust like a mini family business. So I ordered pizza the other night. It's run by a family. They have a separate company, and that company has a founder. That's the grantor of a trust, as you can see here on the slide. That company has a president. That's a trustee, the person who makes all the decisions about the trust. The company does something. It owns real estate. It operates a business. Presumably, it has a bank account. Those are all the things that a trust can have, and it's all done for the benefit of the family members. So if those are maybe the shareholders of a company, those are the beneficiaries of a trust. So a trust, think of it as a small business that you're creating to help provide security for your family, as well as functions for depending on the family members. So let's say that you have children that are under the age of 18. Well, legally, they can't inherit assets in their own name. I have an 18-year-old. I'm going to posit to you that you don't want 18-year-olds inheriting a lot of money in their own name. Not that they're not legal adults, and not that they're not intelligent. They just don't have a lot of life experience to know what to do with that. So by having a trust, you could have a beneficiary who's a child and have a trustee who is another family member, and that trustee can provide guidance to the beneficiary, use the trust on their behalf, and eventually turn the money over to the beneficiary. For married couples, oftentimes we use taxes, we use trust for tax reduction. Right now, most people don't have to worry about an estate tax. If you happen to have north of $22 million right now, yes, you need to have a conversation about that. But if you have assets that are less than that, you may notice that the government just spent $3 trillion that we didn't budget for. There's only one way the government makes money, and that's through taxes. So I'm expecting a lot of changes coming up over the next several years. When there is an estate tax, using trust is a way that you can actually reduce the estate tax and maximize the wealth that's passing to your family. But the single most important aspect of trust is asset protection. Now, what do I mean by that? If you create a trust for a family member and you put your money into the trust, and this is whether you create an irrevocable trust while you're alive or you create a trust inside of your will, creditors of the beneficiaries cannot get to that money. So what does that mean in real life? If you leave it to a child and the child gets divorced, the money in the trust is never on the table from a divorce perspective. If you leave money to your spouse, and your spouse is an entrepreneur and runs their own business, and something unexpected happens, like a global pandemic, and the business is failing, any debts of the individual, anything they guarantee the lease, they guarantee the bank loan, the assets in the trust cannot be used to satisfy that, even if there's a judgment against them. We see a lot of adult children who maybe didn't have sufficient health care and they have large health care costs. Again, the money in the trust is only available to the beneficiary, cannot be utilized to satisfy their creditors. When I do my planning, we have trust at the heart of all of our planning. And lots of times what we'll do is people say, well, I've got adult children. My children are 38 and 42. They don't need financial management. Fine. We can set up a trust for them. It's for the benefit of them and their children. And the child is the trustee. They're the president of the company that's there for the benefit of their family. They can invest the money, they can spend the money, but should something bad happen, the security is there for your family. And in my mind, that is one of the greatest gifts that you can give with estate planning. So Crystal, any comments on trust before we go to the next slide?
Trusts are for more than just the wealthy. You hit the nail on the head in the beginning. That's it for me.
Excellent. Next slide.
So who are your fiduciaries? Who are the people who are being appointed to manage money for you, either during lifetime or after you've passed away, as well as not just manage money, but also managing decisions that could have a financial impact on you? So an executor and also the role of administrator, for those of you who have heard that term. I'll mention administrators first. Administrators are appointed for estates where people did not have the opportunity to plan. Hopefully, for those of you that are joining us today, you're never going to have an administrator appointed for your estate, because that would mean that you never got that will done that would alleviate the need for the court to say how your money is ultimately going to be distributed. But for those that are familiar with that term, an administrator and an executor in New Jersey have the same function. It's just that the executor has been appointed in a will. The executor does not step in to act on your behalf until you're gone, until you have passed away and your will has been probated. So that person, we think, is usually going to be in that role for about a year. It could be more, it could be less, but whomever you're appointing as your executor would have the responsibility of collecting your assets, filing your last income tax return, filing any death tax returns that may be due for you, be it estate tax, inheritance tax, for example, and ultimately has the responsibility of paying your creditors and paying the beneficiaries of your estate. So this job, call it a year, maybe two, but it really shouldn't go beyond that. A trustee, Deirdre just talked about trusts, and so the trustee is effectively that business manager that we were talking about, that person who is responsible for holding the assets and making distributions or payments out of the trust consistent with what the trust terms say. A trustee can serve for a long time, depending on the terms of the trust. If there's a trust that has a 5-year term, then the trustee is going to work for 5 years. If it's a trust that's for the lifetime of your minor child that you're appointing in your will, think that if, for example, that trust says that the trust would terminate when your child is 35 years old, you don't know how long your trustee is going to be serving, because it would depend upon the date of your passing, but you at least know that you would need someone in place until your child reached that 35 age in that example. Guardians are extraordinarily important and are probably the biggest issue that clients have in identifying who will serve in this role. So for my younger couples, this is typically an issue that will have us, instead of getting the wills drafted and signed right away, it may take a few months because there may be some discussion as to who should serve. For those who have children that are minors, the appointment of a guardian is where you say what is to happen and who is to take care of your children if you are no longer here and can't do it for yourself. So I always tell couples, especially couples of minor children, They don't have to say the same thing. So your will and your spouse's will can name different guardians, and it'll just be up to who dies last as to who the guardian would be. That's not really comforting for a lot of people, but at least it gives you an example of trying to get through a tough decision and getting something on paper while we're having the disputes that happen. Another guardian that's important is when someone is serving as guardian of an individual who has been found to be incapacitated by the court, which means that they're no longer able to manage their legal, medical, or financial affairs. In that circumstance, someone who has been appointed as a court-appointed guardian is able to name a successor in their will. That does not mean that the court is going to just accept the appointment. Ultimately, the decision is made by the court, but it does at least give a sense of what one's desires would be. An attorney in fact, also called an agent under a power of attorney, which we're going to talk about powers in a moment when we do the checkup for that. That person can act on your behalf to stand in your shoes, effectively be you for legal and financial affairs during your lifetime. The power of attorney, however, terminates. It dies with you. So if you've appointed your daughter as your agent under your power of attorney and you don't have a will, please know that your agent daughter is not going to be able to access your money when you are gone. At that point, it is the administrator of the estate, in my example, if you don't have a will. If you do have a will, it's the executor of your estate who can step in at that point. The healthcare representative. So healthcare representatives are the people who you're appointing to be your mouthpiece, to make medical decisions for you if you can't make them for yourself. And with all of these appointments, it is critically important to name successors. While we always have wonderful plans, we want to have a backup plan, and sometimes not just a plan B, but also a plan C. So I strongly encourage people who have existing documents but only named one person to seriously reconsider and sign docs that name someone to stand in the shoes of the people who've already been appointed. Next slide.
So since this seminar is an estate plan checkup, what we did is we actually prepared lists for you so you can pull out your own documents and look at them. I happen to see the weather forecast for tomorrow. It's supposed to be raining all day on Saturday. I suggest a rainy weekend is a great time to go and pull out your documents. First question, do you know where your documents are? You may think that you know where they are. They may be in a different location. Pull out the copies so that you have. If you don't have copies, contact whoever drafted them and ask them to send you copies. Find out where the originals are, because should something happen to you, you get hit by that meteorite, we do need the original will document, and sometimes that can be a bit of a treasure hunt to find. Take a look at your documents. The tax laws have changed dramatically. As recently as in 2018, New Jersey had an estate tax, and there were planning frameworks that were in your will that made sense when New Jersey had an estate tax, but don't necessarily make sense now. The federal exemption is $11,580,000 right now, so it doesn't, only impacts a small percentage of the population, but that's scheduled to go down to about $6 million in 2026. And as I mentioned, these laws can change all the time. When we're doing planning, we're making our best guess as to what's going to happen. So take a look at your document. The other tax update is that in January of this year, the Secure Act was passed. And the Secure Act made significant changes to how a non-spousal beneficiary, a child, a sibling, can inherit a retirement account, an IRA or a 401k. Your documents, if they were drafted before probably December of 2019, they're not going to have appropriate language in them, not because your attorney didn't do a good job, but because it was a whole new law and it's not incorporated into the document, so you need to look at that. For folks that have worked with us, just give us a call. We'll go through your documents with you. Specific bequests. A lot of times people have said, I leave $10,000 to this person, $5,000 to that person. I leave the shore house to the other person. Is this still somebody you want to leave money to? Is this the right amount of money if your assets have changed? If you're leaving them a thing, does the thing still exist? So definitely look at that and make sure that those are in place. Pets. It might be as I get older, I have more and more clients that are more concerned about their fur babies than their actual adult babies. And it's usually then if there's grandchildren, it may change. But who's going to take care of your pets? Are you going to give some money to them to be able to offset the cost of care? Give some thought to that the same way that you would for everybody else in your family. Look at those trust distribution terms. Now, unfortunately, the way that estate plans are written, the language is very dense. But give a call to the attorney who drafted it. And, what does this say? If I were to pass away, what exactly does this mean? And does this still make sense? If it does, great. If it doesn't, maybe consider some changes. And as Crystal said, look at your executor, your guardian, and your trustee. The most frequent reason that estate plans are updated are to change who the people are that are in that role. And that can be done quickly, a codicil to the will, an amendment to a trust to be able to do that. But where you've changed, the people that you've named as fiduciaries have changed also. And we can write the most gorgeous plan in the entire world, but it is the people that you name to carry it out that are going to be the litmus test of how successful it is. So make sure that you're naming people and successors that you're comfortable with. Next slide, please.
Earlier, we were talking about identifying assets and identifying ultimately what you have that will pass to whom. There's a misnomer out there that if you have a will, it controls all of your stuff. And that simply is not true. So there's a designation of what's called probate assets and non-probate assets. Probate assets are controlled by wills. Non-probate assets are not. Non-probate assets can consist of joint accounts or property that has a joint designation on it if there's a survivor that has been named on the deed, insurance policies, retirement accounts, IRAs, 401ks, 403bs, and pay on death designations. For joint assets, whether that be a home that has a joint ownership, Deirdre and I own a property at the shore jointly with rights of survivorship. If that were to occur and I pass away first, Deirdre would be the sole beneficiary or the sole owner of that property. Was that really what I intended? Same example, Deirdre and I have a joint checking account at a local credit union and I pass away. She would be the presumed beneficiary of my undivided 1/2 interest in that property, in that account. And is that really what I intended? In New Jersey, the presumption is that if you have a joint account or a joint ownership designation, that you intend for the surviving joint owner to receive that money. And that may not be the case. Now, you can rebut that presumption. So you can show but you're going to be dead. So it's going to be your loved ones could show that, ultimately, my husband could say, my wife did not intend for Deirdre to inherit half of that shore house and that joint account. The intention was that I would be the surviving owner of that with Deirdre. And we only did that because Crystal spends more time in the office than at home. And so, it would be easier for Deirdre to have access to those funds. So you can rebut the presumption by showing that the account was set up, for example, for convenience purposes, but otherwise the presumption is going to be that it was your intention for the joint owner to own it. We see this as being something that's critically important for you to check on when you're looking at your estate plan, because ultimately, especially as we age, one may decide to name son number 2 as a joint owner on a bank account just so that son will be able to write checks if something were to happen to you. Well, if there are 3 children, effectively what has been done is the other 2 have been disinherited from the value of that account. So it is important just to consider and look at and ultimately make a decision as to whether or not a joint designation is appropriate or some other type of ownership structure, such as a sole ownership with a power of attorney in place for that. Insurance proceeds as well as retirement accounts have a beneficiary designation that's associated with them. And so whomever has been appointed as or designated, named as the beneficiary is the person who's going to inherit that property, regardless of what it is that your will says. So I'll use a younger couple, for example, that has children under 18 or even children over 18 that they don't want to receive a significant amount of assets outright. So let's say that person has a life insurance policy that's a $500,000 policy, and they've got 2 children that are over the age of 18. In their wills, their will may say that any share that goes to a child under the age of, let's pick a number, 25, is going to be held in trust in that mini business that Deirdre were talking about. Well, that's great since it's in the will. The will would control anything that is in your individual name at the time of your death. But with respect to that insurance policy, the only way that those insurance proceeds would pass to that trust that I just mentioned is if the beneficiary designation says that. So it's important primarily to do 2 things. One, make sure that the ownership structures you have in place are consistent with your intentions with respect to how it would be distributed at your death. And then second, make sure that your beneficiary designations match your overall intention with respect to your estate plan. Next slide.
All right, so the next document is, because there were the 3 basic documents, the will, the power of attorney, and then the healthcare power. You're looking at your power of attorney. What do you need to focus on? Is it durable? What does that mean? Is the word durable? This is a durable power of attorney in there. The reason you need to do that is, fun fact, under New Jersey law, unless your power of attorney says that it's durable, as soon as you become incapacitated, it's no longer effective. But the whole reason you probably have one in the first place is in case you become incapacitated. So you need to make sure that that's in there. Does your power of attorney allow your agent to make gifts? Can they transfer your money to somebody else? If so, are there restrictions on that? Now, why would you want them to make gifts? Both Crystal and I work with a lot of older individuals, and there may be reasons to make transfers to be able to protect the overall wealth from the very expensive realities of long-term health care costs. But if a power of attorney doesn't allow somebody to make gifts, then we can't engage in that kind of planning if somebody becomes incapacitated. Who's your attorney in fact? Sometimes people, they're like, oh, I'm going to name my oldest child. Well, if your oldest child lives in Bali and is an artist, and your younger child is an accountant who lives the next town over, I would suggest to you that your younger child might be better suited for this particular role. It's not a gift being a power of attorney. It's a job, and you want to name the person who's best for the job. And then finally, is it notarized? If a power of attorney is not notarized in New York or New Jersey, it is not valid. So you need to make sure that the document is notarized. Next slide.
So for healthcare powers, 3 critically important considerations when we're looking at whether or not what we have is what we need. Is there a living will well, let me back up and say this. For an advance directive, it can come in a number of flavors, okay? It can be one document that accomplishes all 3 of these goals that we're about to talk about, having a living will, having the appointment of a healthcare representative, and having an HIPAA authorization, and we'll speak about all 3 of those separately. Or you can have healthcare powers that effectively are 3 separate documents that say this. My practice preference is to have them all in one, but really it depends on you and what it is that you want and how much power you want to give someone today. The living will portion is where you say what happens if your doctors felt that there was no medical likelihood that you would survive a terminal condition or illness short of a religious miracle. Would you want to pull the plug or not? Do you want that ventilator or not? Do you want to have artificial food and hydration or not? So that's what the living will says. Some people want to have a living will in place, but don't necessarily want anyone to know about it right then. And so for those folks, we would typically separate the living will from the other documents, but 99 times out of 100 in my practice, we're putting them all together. The healthcare representative, that's your mouthpiece, your medical decision maker. While you are alive and while you have the ability to make your own decisions, your healthcare providers will always ask you. They don't care who you've appointed as your representative. If you are able to speak, they're going to ask you to make a decision. If, however, you cannot make a healthcare decision for you, or if you're laying in that bed and you just say, you know what, I signed a healthcare proxy already, why don't you ask my representative? Then they will ask your rep. The healthcare representative stands in your shoes to make those medical decisions for you if you cannot make them for yourself. For this document, this is probably the most critical in my world of any others, because there are other mechanisms in place for us to take care of you if you don't plan. There's some type of law that's going to allow us to do something if you do no planning. For healthcare decision making, on the other hand, this is a very personal appointment. It should be someone who you trust to be able to make a decision that is consistent with what you would want. If you have a child who cannot imagine life without you ever, and would never be able to say to a doctor, my mom or my dad would not want to live like this, turn the machine off. That may not be the person who you want to appoint as your healthcare decision maker, right? So it's a personal decision, but you want to appoint someone who you think is going to actually implement the decision that you want. And finally, it is impossible for a healthcare representative to make an informed healthcare decision if they are unable to access your confidential health records. So a HIPAA authorization is important because it allows the people who you are appointing in the role of representative to access the records that would be necessary in order for them to make an informed decision for you. Now we're going to look at the impact of minor children. We can go to the next slide.
So this is going to be a summary checklist, which Crystal's already spoken about, guardians. So before I get to that, also, if you have any questions, which I probably should have said at the top, if you put them in the questions box, we're happy to answer them at the end. My apologies for missing that. Fun fact, public service announcement. The only place you can name guardians is in a will. If you have any family members that have children, it is incumbent upon them to name guardians. If they do not name guardians, a judge who you have never met, who is cranky because you did not fulfill one of the fundamental responsibilities of being a parent, will be the person who's deciding who's going to raise the children. That is not a plan that anybody wants. So if you do have folks that have minor children, please have them do a will so they can name guardians. New Jersey also allows you to name a temporary guardian, a standby guardian. This is somebody who has the authority to act immediately if you're incapacitated or if you've passed away. This is particularly important. There are times when we have folks where the guardian lives overseas and they would need time to get here to be able to do something. So maybe they'll name a neighbor as guardian in the meantime. And then finally, we've talked about the value of having trust for children. You have to have them if the children are under age 18. You should have them until they reach a point of financial maturity. In my drafting, I do trust for lifetime with a mechanism for the child to become their own trustee. So maybe at age 25, they become co-trustee with Uncle David, and then at age 30, they become their own trustee so that those assets stay in trust and we get the benefit of that asset protection. But you have to have the trust that are going to be there for them. And again, look at your documents, make sure you understand them. If you don't, call your attorney to be able to say, hey, can you explain this to me in English? Next slide.
So long-term care. Long-term care is an important consideration because an estate plan only works if you have money left to pass to your loved ones ultimately when you're gone. Long-term care is one of the most critical ways that money ends up getting spent later in life or in the event of something that debilitates us. In New Jersey, the average cost of a nursing home setting, which no one is jumping to go to, but could happen, is about $11,000 per month. And regardless of how much money one has, No one can sustain paying $11,000 a month for a significant period of time. So there are multiple ways in which we look at ensuring ultimately that you have money to pass to your loved ones while at the same time having your long-term care costs covered. And so the Medicare program is a program that will provide a very limited amount of rehab, but does not cover long-term care costs. So for one who would need, let's say, a nursing home setting to have some rehab from a broken hip, best case scenario, 100 days, but only the first 20 are covered at 100%. Every day after that, from 21 to 100, is $176 a day. So it's really expensive. We look at long-term care insurance and other insurance coverages thereafter to help subsidize some of the costs of long-term care. And for those that are at an age where the cost is still fairly reasonable to look into long-term care insurance, I encourage people to really do that. To the extent that there are no private health insurance coverages that can cover long-term care as well as long-term care insurance, we look at whether or not there are other benefits that may be available, benefits either through the Veterans Administration or the Medicaid program. Both of those programs are essentially welfare programs that will cover someone when they have run out of money. So to the extent that health insurance and long-term care insurance doesn't cover you, which oftentimes it will not, we look at private pay coming out of pocket to cover expenses. And once assets have reached a certain level, the Veterans Administration has benefits available for those who have served our country, either by way of being active duty or being married to someone who was in active duty. And then the Medicaid program is the payer of last resort. There are mechanisms in which one were able to preserve assets while at the same time later, 5 years later, that is, qualifying for long-term care covered through the Medicaid program. And that's by doing asset protection planning. I'm going to answer one of the questions that we received because it's on point to this issue. And the question was, can a nursing home go after funds that are in a trust? So the first response to that is there are a number of different trusts that one could have with respect to their estate plan. When we're looking at preserving assets and having an asset protection plan in place that allows one to maybe set money aside for their loved ones while at the same time retaining enough money in their own individual names to get through a 5-year period, which is a period of time that a Medicaid agency would look at whether or not you've given away money that could disqualify you for benefits. In doing that type of planning, there are, and the questions are coming quickly, sorry, there are a number of trusts that could be set up. Special needs trusts are a mechanism by way one could set money aside either for themselves or for a loved one to qualify for government benefits. There are specific rules to special needs trusts, first parties versus third party special needs trusts, that are beyond the scope of this conversation. All I will say with respect to that is, if someone is transferring money to a trust for purposes of their own qualification for Medicaid benefits, to the extent that it is done appropriately with certified elder law attorneys like myself and like Deirdre, the state agency would not have the ability to recover any of those funds at your death. If, on the other hand, I become incapacitated and my money is used to fund a trust for my benefit and I'm under the age of 65, a special needs trust is a mechanism by which I could qualify for Medicaid and have money set aside to supplement me. And in that example, the Medicaid agency would have a right to recover. So long story short is multiple trusts that can be used, but to the extent that we're doing an asset protection plan to preserve assets for you, as long as it is properly drafted, the Medicaid agency would not have a right of recovery.
So let me
anything else on that?
I just wanted to add on to that. So to answer the question with something like that, unfortunately, the beginning answer is always, it depends. It depends on what kind of trust. It depends on your family situation. It depends on the amount of assets that you have. One of the greatest pleasures that Crystal and I have is sitting down with a family to actually understand what their specific circumstances are so that we can go from an answer of it depends to here's a plan where you can actually be able to meet your goals. So some of the limitations of the seminar in terms of doing that. So if you can go to the next slide. As we're looking at your estate plan, some practical questions that you just need to have so that your estate plan is as valuable as it can be. What are your assets and liabilities? Because if you do get hit by my meteorite that I keep talking about, and your filing methodology, which is perfectly fine, is that you have one of those black bags that you got at a trade show 6 years ago, and all of your important documents are in it, and it's in the upper shelf of your closet. That's a great filing place. It's safe and secure. Not so good if nobody knows where it is. So you should have a list of your assets and liabilities just from a general level, and then keep those with your estate planning documents. Who are your advisors? If something happens to you, how do you even know if you have life insurance? Well, if you have a name of a life insurance advisor there, they know to contact them. Your accountant who can help with taxes, whatever the case may be. Your fiduciaries. How do we get in touch with your fiduciaries? Well, we usually have addresses. These days, it's helpful to have cell phone numbers and emails as well. Passwords, passwords, passwords. So many people now do all of their banking and items online. If somebody passes away, your executor needs to gather up your assets. If they have no clue where your assets are, that's a problem. Trying to guess and get into your account is actually a violation of federal law because of the Communication Storage Device Act. But having said that, what we want to do is you should have a list of passwords. I highly, highly recommend that people use a password manager, Dashlane, LastPass, something along those lines. Have one password in a secret special place. Your executor gets access to that one password. They can then have access to your information. And then finally, where are your documents? Again, if they're in that black bag in the upper closet, awesome. Let somebody know about them. Next slide.
So, important conversations to have with your loved ones. What are your end of life decisions? Do you want that pull the plug, or do you want everything humanly possible to be provided to you regardless of whether or not you're responsive? There is no right or wrong answer for these types of decisions, and it is a personal one. So have those conversations and make sure that your loved ones are aware of what your desires are. Family love letters. Unfortunately, I have only seen this twice, and I wish that I've seen more. One of which was in a will, which historically was the testament part of a last will and testament, where you're expressing your appreciation, your love, and your desire for your family and why it is that you value them and want them ultimately to receive the things that you have left for them. It's more than just saying, I love my ring and I want you to have it, but it's the expressions of, I remember when you were a kid, you always used to admire that diamond ring, and I thought that this would bring you such joy and happiness. The things that you would say at a wedding are the things that you see in those family love letters. Trustee and guardianship guidance. It's really just giving folks a roadmap, letting them know what it is that you hope that they will do. If you're appointing a guardian for your minor children and it's a lifetime, if you're appointing a trustee for your minor children and it's a lifetime trust, the way Deirdre was just talking about before, perhaps you want the trustee to really think about ways in which to use the money that can further whatever the passions and desires are of the child, and not be so black and white with, is this for education or not? You know, whatever it is that you envision for yourself and for your child, that those things be put, or at least reduced to some type of letter writing to let them know how it is that you wanted them to serve in that role. Same for guardian. Guardianship guidance is important, especially for people who are serving as guardian of our loved ones with intellectual and developmental disabilities. You want to let the people who you trust know how it is that they need to take care of your child and to stand in your shoes. And we can go to the next slide, which is questions thereafter, right?
Right. Well, actually, we take questions now. If you can go back to the slide, because a lot of the answers to your questions are actually at our new website, 40planning.com. So we are, if you can't tell, we're a little excited about this. So we would really love if you would visit it, give us feedback, send us an email, and you know, let us know. But some of the questions that you asked today, and Crystal, I'm going to throw the first one out to you. Do you need a guardian for your kids if you're divorced and your spouse would get custody upon your death?
So no, if there is another, assuming that that the divorced spouse is the natural parent of the child. So assuming that, no, you do not need to appoint a guardian. A guardian appointment is going to step in once there's no longer a natural guardian or a parental guardian that is living.
So having said that, I usually do recommend, first of all, if people are getting a divorce, that they both name in their documents the same person as the next guardian, so we don't have grandparent wars. But you should name a successor, because the same thing, because if something does happen to your spouse and you are the parent who named who a successor guardian would be, that's what the courts would look to. Another
Agreed.
question.
And one thing I do want to mention there, for couples that are divorced, there have been questions about appointing someone other than the remaining parent. So that question does come up. The truth of the matter is, no, we will include language in the will that talks about all the reasons why you don't want person to serve, but ultimately a natural guardian, a natural parent is going to serve in that role.
Excellent. So another question, is there a difference between a revocable and irrevocable trust? Huge differences between them. A revocable trust has no impact for tax purposes, asset protection purposes. It is a substitute to you or to your planning. So there are reasons to use it. It's a tool just like any tool is, but an irrevocable trust is one where you no longer have control. You, the person who created and set up and funded the trust, no longer have control over it. And as I said at the top, it's usually done for a specific purpose: income tax planning, estate tax planning, asset protection planning, something along those lines. So while a revocable trust is a tool, they are not interchangeable at all. The next question down here, Crystal, how do you feel about hiring a professional trustee?
So professional trustees are great. It will depend on the type of trust that we're talking about. The biggest consideration with respect to professional trustees is the cost. So it really just boils down to whether or not it's an expense that you want to incur. Also, if there's a circumstance where you believe that you want to provide the trustee a bit more discretion, and I'll give an example of that. Oftentimes for that, it may be better to have a family member than a professional trustee. I'll give you an example. You've got a lifetime trust for the benefit of your child, but at the end of the day, you want the trustee to consider distributing all the money sooner in life if there's really no reason to hold it in further trust. If that were the case, professional trustees, I have found, are less likely to just bust the trust in that way. But to the extent that the terms that you are putting in place are consistent with what you think you're going to want for the long haul, a professional trustee is great if you financially, want the burden.
Yeah. So my answer to that also is it's another it depends situation. It depends on who the family members are, who might be alternative trustees, and it depends on who the individual is. Sometimes you might have a difficult family situation that no one else should be taking on the burden of. Other times you may have a very complicated, from a financial standpoint, situation. You really want to have that professional guidance. So the last question that we have before we end here, and Crystal, I'm going to throw this out to you. How do you deal with Social Security death benefits and minor children in trust? How does that all come together?
Okay, so Social Security death benefits, that's an income benefit. And the person who would be able to manage that would be the representative payee that is appointed by Social Security. So the Social Security death benefits are not going to automatically go to a trust for a minor child. The Social Security Administration has a mechanism to make sure that money that's for a minor child or for any Social Security beneficiary goes for their benefit, and that's the appointment of a representative payee. You certainly could say in a letter of instruction that it's your desire that XYZ person serve as representative payee and that rep payee pay the monthly income into the trust, but it would not be a requirement, and Social Security would not honor any type of direction in a will or otherwise that the money be assigned or required to be paid to the trust.
Excellent. So I hope everybody found this will checkup to be valuable. Again, we encourage you, take out your documents. I find that over time, what you think they say and what they do say diverges a bit. Also, your estate planning documents represent a moment in time. So the analogy I like to use is, let's say you bought a gorgeous coat 15 years ago, and maybe it was hot pink, and maybe it was all the way down to the ground. Would it still keep you warm today? Yes, the function is still there, but would you purchase a hot pink full-length coat today? Maybe, maybe not. Or you might have the situation of the incredibly shrinking closet where the coat just doesn't fit you as well as it used to. Estate plans are like that, so they do need to be updated and refreshed. The most important thing is that you're able to have a conversation around them. Obviously, we're here to be able to speak to you about any questions that you have. But if your friends have questions, because this is what you're talking to in your Zoom tales when you're having them with your old college roommates, it's such an important thing to do. Crystal and I, we deal with families who didn't do any planning, and we work through that scenario. It's not what we would like people to do. We would love people to say, hey, this is an area of the law. I am empowered to basically do almost whatever it is that I want. I just need some education to be able to put a plan in place that totally fits me. And with that, that's what we really encourage you to do. Thank you for spending time with us today. If there's any questions, our contact information is below. Or where can they go, Crystal?
PorzioPlanning.com.
There you go. With that, we'll sign off. Thank you very much for your time today. Take care. Bye-bye.
Have a great day.